Okay, let's go ahead and get started. I'm Charlie Smith, the Executive Director of ESIG, and I want to welcome you to our ESIG webinar series. By now, I presume that most of you are familiar with ESIG and the benefits we provide, as well as our role in the Global Power System Transformation Consortium, or GPST. We serve as lead for Pillar 1, working on the high penetration research agenda with the system operators. More information on both can be found at esig.energy and globalpst.org. We've been quite busy this past year, in spite of the virus constraints. We just finished our annual Fall Technical Workshop in November, and our next major online event is the annual Spring Technical Workshop, beginning in March. Our workshops and monthly webinar series are open to everyone, so please feel free to register anytime on the ESIG website. In addition to the website at esig.energy, you can also find us on LinkedIn, Facebook, and Twitter. Okay, just a few logistical matters before we get started. First of all, phones will be muted for the duration of the webinar to avoid unnecessary distractions. For the Q&A, we'll be using the Slido platform at slido.com. You won't be able to ask questions through WebEx. You need to go to slido.com on your device and enter ESIG9 as the event code. The instructions are also at the bottom of the screen. You'll see a thumbs up button next to the questions to allow you to cast a vote to help prioritize the questions submitted. We plan to save 10 minutes or so for Q&A at the end and then wrap it up at the top of the hour. An email with a link will be provided once the video file has been posted. We also plan to provide short responses to unanswered questions after the webinar, so please don't be afraid to ask your questions through Slido. Okay, so today we're holding part 2 of a 3-part series dealing with the 3 Ps of transmission, those being planning, permitting, and paying. We covered planning 2 weeks ago, and today we'll be covering permitting. Based on registrations, it looks like it will be another quite popular webinar. We'll feature Brett Sumner, a senior partner at the energy law firm of Beatty and Wozniak, headquartered in Denver. Brett is a familiar face to those permitting large infrastructure projects, having been working in this area for nearly 30 years. He is a well-known figure nationally and will cover the development of comprehensive and proactive permitting strategies for successful development of large-scale infrastructure projects spanning multiple states and jurisdictions. His firm specializes in all aspects of siting and permitting involving right-of-way, land access, condemnations, surface use agreements, and surface owner dispute resolution before federal, state, and local agencies and commissions. He counsels energy clients on front-end regulatory matters with the goal of expediting project approvals at the federal, state, and local levels in a manner that reduces litigation risk, a risk known all too well by those involved with transmission permitting. I feel very fortunate to have Brett here with us today. Permitting of transmission lines is not an area where I have any personal expertise other than being aware of the many pitfalls, so I'm particularly pleased that Brett is able to join us to share his knowledge and experience. The webinar today will focus on the siting and permitting challenges that transmission project proponents face and potential strategies to minimize the associated risk. Just a short reminder once again to use Slido at slido.com with the event code of ESIG9 to ask your questions. Okay, without any further ado, let's go ahead and get started. Brett, I'll now turn it over to you.
Thank you, Charlie. I really appreciate it. Good afternoon, ESIG members. I really appreciate this opportunity. I'm really looking forward to it. Because I am an attorney, I have to start with a legal disclaimer. I'm providing a general overview of a lot of different legal issues and providing a general overview of strategies, but this should not be taken as specific legal advice for your company. We do in-house seminars on a company level basis and would be happy to explore those if anyone is interested. We have a lot to cover, and I'm just going to dive right in. When we think about permitting and presentation overview, there's so many things that we can cover, and we're going to focus primarily on federal permitting issues, state and local permitting issues, at how all these three things, combine together and what a company or a project proponent needs to be thinking about as it tries to navigate this process. As we've seen with many electric transmission projects that are covering a wide area in many different states, these permitting processes can take years. There are several in the West that have taken 7 to 10 years. Several more are in year 10 or 11, and they're still working through a variety of state and federal issues. So, from that standpoint, definitely keep that in mind as we go through these things. And, part of my goal is, again, a very high-level overview, and it's really hard to get into the details. But I think once you see all these different parts and how they should fit together or don't fit together, I think you'll have a really good appreciation for, some of the strategies that you need to think about when you're trying to do these projects efficiently, particularly to avoid construction delays, stranded capital, trying to get a return on your investment faster, and that type of thing. And, Charlie mentioned that I've been doing this for 30 years, and just a reminder how old I am. But when I first started this, infrastructure type of permitting practice, I was actually still in law school. And one of the very first projects I worked on was the Alliance Natural Gas Pipeline Project. And this extended from Calgary, Canada to Chicago. At the time, it was the largest construction project in North America. And I learned so much, for that project and applied it to other aspects for large-scale infrastructure and electric transmission and even other areas, involving, significant geographic areas and numerous, federal, state, and local jurisdictions. So at this biggest level, I like to equate these types of permitting endeavors as playing four-dimensional chess. And you're doing four-dimensional chess at three different levels: federal level, the state level, and the local level. And these four dimensions that you need to be thinking about are law, policy, politics, and business. And it's really interesting because not only are you looking at these three different planes, but there's so much interaction. The state and local considerations that come into account at the political level often bleed over into the policy level. When you're considering from a legal standpoint, you're looking at it from both trying to efficiently have your project permitted, but you're also trying to do so in a manner that is going to reduce your litigation risk. Because unfortunately, many of these projects, regardless of size or type, are challenged in federal courts and in some cases before state courts and state agencies as well. And when you're going through all the different slides this afternoon, just keep this four-dimensional chess in mind. So first, we're going to give a quick overview. What has been done so far in the United States to try to make electric transmission permitting more effective? And we're going to rewind the clock about 15 years to the Energy Policy Act of 2005. There were three provisions of this congressional legislation that related to electric transmission permitting. The first was the designation of Western energy corridors. This focused primarily on the 11 contiguous western states, and the goal here was to identify specific areas where there could be a programmatic environmental analysis accomplished for these corridors to make permitting for pipelines and electric transmission much more efficient and much faster. Unfortunately, this project was subject to several legal challenges. After several years of litigation and delays, there was a settlement with the federal government and these environmental organizations in 2010. The concessions made there provided more process, provided more administrative things to accomplish, but it was essentially rearranging the deck chairs. And from my perspective, we really haven't seen a lot of traction, in terms of using Western energy corridors to make permitting be accomplished in a much faster and more efficient manner. The second area is the designation of national interest electric transmission corridors. This was after a congestion study was conducted, and the goal here again was upon designation, to try to streamline permitting processes. There were two corridors designated under this provision. One was in the Mid-Atlantic, covering 7 different states in the Mid-Atlantic region, and the other was in the southwestern United States, covering primarily California and Arizona. But once again, there were numerous legal challenges filed by a variety of environmental and stakeholder groups, and unfortunately, they were successful. In the Mid-Atlantic, the decision went all the way up to the U.S. Court of Appeals for the Fourth Circuit. They overturned the designation of that corridor, and they also removed, the backstop authority that was provided to FERC, to overrule in case there was delays at the state level or, a rejection of the project. And also in California, in the U.S. Court of Appeals for the Ninth Circuit, it also overturned that designation. So as you can see from a litigation standpoint, it's really been piecemeal. It really hasn't been able to accomplish a lot, in terms of broad-scale infrastructure projects, such as electric transmission. There was also an executive branch memorandum of understanding between various departments, including the Department of the Interior, Department of Energy, Department of Agriculture, and Department of Defense. So we fast forward 10 years, and there was something called the FAST Act of 2015. FAST stands for Fixing America's Surface Transportation. And as we'll see in a few more slides, this actually does also apply to renewable energy and electric transmission projects. In 2017, the president at the time did issue an executive order to expedite infrastructure projects and permitting. This included providing more accountability from federal agencies and trying to have some more coordination. And there have been other efforts along the way, various other memorandums of understanding between federal agencies, various policies to try to improve federal rights-of-way. But at the end of the day, when we look at the projects that have been approved and have been able to be constructed and moving forward, we're still talking about a multi-year process. And I think that we're still looking for that right type of legislation that can provide more centralized authority. And we can get to more of that in the Q&A section. Let me try to advance the slides here. FAST Act of 2015, it's called FAST 41 because it amended Title 41 of the U.S. Code. And as I mentioned before, it has broad application. It's not just for highway projects. The most significant component of this legislation is the creation of something called the Federal Permitting Improvement Steering Council. There is no fancy acronym for that. We call it the Steering Council or the Permitting Council. And it's really designed to be an oversight entity. It is attached to the Office of Management and Budget, which is part of the White House. And it's actually been used quite successfully over the past 5 years for a whole host of projects. If you go to FAST 41 on their website, they actually have a dashboard, and you can look at the projects that have been approved using this process and ones that are still in the works. Again, it covers a wide array of conventional energy, renewable energy. I think there are some smaller scale transmission projects involved. And at the end of the day, I think this is a tool that can be used a lot more in the future. And it really is going to, you need to have a strong person as the point person, that can kind of help herd and corral, the various federal agencies. Or if there's a log jam, their job is to go in and try to break that log jam on the federal agency side of the equation. I'm having trouble advancing my slides. We're going to switch now to just a high-level overview at the state and local level and things that you need to consider. Every state is different. A lot of states have agencies specifically related to siting, or they have siting councils for large-scale projects. Numerous projects related to, obviously, electric transmission fall within public service commissions. But it really does vary depending upon the state and how they have it structured. Some states have actual siting legislation that provides a much more streamlined process, and some don't. And when you're thinking about the development of these from a public utility standpoint, it is still very state-focused, very localized, very regionally focused, and it's not something that necessarily lends itself, to a large-scale linear project like an electric transmission line that's traversing through many different states. Another consideration is at the local level. Many counties and local governments have their own permitting requirements that need to be accounted for and taken into account. And the overlay for all these various permitting issues at the state and local level is you really need to have a strong community outreach program. I often liken it to almost like a political campaign, but you want to make sure that you're proactive in the local community, proactive with local decision makers, whether it's a county commissioner board, a mayor, whoever's involved. But the more they can learn about you in advance, what your project's about, what the broader goals of the project are, to be that friendly partner, to be that friendly neighbor, so to speak, that really, really goes a long way. I've seen instances where the exact opposite has happened, and the first time the local decision makers hear of the project is when it's time to make a decision on a permit. And that can cut both ways, but if there's any level of local opposition or if there's a backlash against it, that results in all sorts of different delays, and in some instances really results in litigation as well. The not in my backyard syndrome, the NIMBY syndrome, is unfortunately alive and well, particularly when it relates to electric transmission projects. One other consideration relates to, there is a lot of overlap. When you're trying to navigate things at the state level, you have to take into account certain federal statutes. One example, the Clean Water Act, there's delegated authority to the states, regarding certain permits and regarding water quality and water permitting. The Endangered Species Act, we're going to talk about that. That applies across the United States, whether it's federal or private land, but also state wildlife agencies have their own, permitting requirements for certain species at the state level as well. In terms of another local issue to think about, it really comes down to, to land access. And, part of this process is, many states have some form of a certificate of convenience and necessity type of permit. And when you obtain this permit, that does often provide that eminent domain authority where you can actually obtain access to that. One consideration is when you have these public certificates of convenience and necessity, some states require that you obtain all your local permits first before you obtain your state permit. And some do the exact opposite. You obtain your state permit, and then you go through your local compliance issues. And that's just another factor to consider, when you're working on these siting issues, so you're not avoiding delays on one end or the other. In terms of working through eminent domain and condemnation procedures, to obtain access to this land for construction, all the states essentially model the state statutes off of the Fifth Amendment of the U.S. Constitution, which prohibits unlawful taking of private property without the government providing just compensation for that property. And eminent domain is usually what you want to do as your last-ditch effort. Oftentimes you want to try to have a collaborative process with the landowner, enter into a surface use agreement with the landowner so that you have that access for construction and maintenance, for the project, and then when the project is in operation. Some of the considerations for surface use agreements, it really comes down to appraising the value of the land, listening to the landowner. If you have a rancher, they might have certain considerations that they have in terms of reclamation or in terms of improving other areas of their land. They'll have very strong opinions about where they might want to site a road for construction, or where they want to put that, right away. And it really comes down to, having a collaborative negotiation. When I think about these things, the most important thing in my mind is you really want to hire a local land company. They're familiar with the community. They're familiar with property values. Look for a land company that is permitted or dealt with similar issues involving highways or involving pipelines or involving other transmission projects. That is really going to go a long way. So one, you've got your pulse on the ground regarding your landowner, but two, the landowners are going to have that comfort level, or at least they're going to know someone that speaks their language. In other words, you don't necessarily want a land company from New York or California, trying to negotiate with a Wyoming rancher. It really can have unintended consequences. Separate and apart from those agreements, in order to obtain it for construction, just to be able to do siting, you need to have an agreement to be able to survey that land, and you want to avoid a situation where there is trespass. Oftentimes, you'll find that landowners are very motivated to reach an agreement with the project proponent, because from their consideration, if there's an eminent domain proceeding, that involves the landowner having to hire an attorney, the landowner having to hire an appraiser, having to hire an expert witness, and actually going through that litigation. Another thing to think about, though, and I hearken back to the Alliance Pipeline project, we had very, very proactive land companies that did a great job with landowners. But that said, we still had over 1,400 condemnation and eminent domain proceedings in 4 different states. And at the end of the day, most of the states have something very similar. When you have the equivalent of a trial, or you have a jury, and it's a jury of your, the locals. So you've got your farmer, that you're trying to work in an agreement with, and the person that's deciding the value of that land is going to be his or her neighbors. So that's a consideration on the other side of the equation. We call it being hometowned, and we've seen this play out in all sorts of different ways. So switching gears from state and local, focusing a little bit more in terms of what federal statutes are involved. And I think it's important to realize that many of these federal statutes and federal permits are required even on involving private lands, even involving state lands. It doesn't have to be federal lands where these are involved. And we're going to talk about particularly the National Environmental Policy Act and the Endangered Species Act. These statutes really are where the delays happen, and these statutes really are where you end up having a lot of litigation. First, the National Environmental Policy Act. This actually requires there be a federal nexus for the statute to apply. Federal nexus means, there's some component that requires a federal permit. And one thing that often is litigated is, well, how far does that environmental analysis have to go? If you're on primarily private lands and you have one discrete water crossing and you need to obtain an Army Corps permit for that water crossing, the scope of analysis is traditionally confined to that discrete area and not the entire project. But environmental plaintiff organizations really make the argument that, even though you're looking at that one discrete water crossing, you have to analyze the entire project to look at what those cumulative impacts might be. And that's something that requires a lot of work and due diligence on the front end. One of my biggest recommendations is having a very experienced environmental contractor to work with that understands these types of issues and can work closely with your legal team, to really be proactive to try to prevent or at least minimize what that risk looks like. And one other thing about NEPA is it's a procedural statute. It's not called the Environmental Protection Act. It's the Policy Act. And its real goals of the statute are, to involve the public so that they understand what's going on, but also to inform agency decision-making. And through this entire process, this is where the federal agencies determine what types of restrictions or conditions of approval or mitigation requirements that your project might have. I'm not going to go into too much detail here, but traditionally for large-scale projects spanning multiple jurisdictions, you're going to have to do something called an environmental impact statement. Our abbreviation is often used as an EIS. An environmental impact statement is often comprised of thousands of pages and multiple volumes of environmental analysis. It's looking at the potential impacts the project might have on every conceivable resource that it might affect, from air quality to wildlife issues to water issues and a whole bunch of other things as well. And there's a formal process. Things are published in the Federal Register. You're required to do public, meetings, to inform them of what the proposed project is. There's a comment period where members of the public and stakeholders can submit comments to the federal agency on what their issues of concern are. Drafting an environmental impact statement often takes many years. You have the option of letting the federal government or the federal agency take the lead, or you can hire a third-party contractor to take the lead. Obviously, hiring a third-party contractor, they're more inclined to move at the speed of business than the speed of bureaucracy, and can be a lot more efficient along the way. But even after you finish that environmental impact statement, spanning thousands and thousands of pages, you still have to, the federal agency still has to do an actual record of decision. This is only hundreds of pages, but this actually spells out what the project proponent has to comply with and what the various restrictions are or limitations are on that project. The other big one is the Endangered Species Act. And it's a misconception that the Endangered Species Act only applies, involving federal lands or public lands. It applies wherever the particular listed wildlife species is located or whether the listed plant species is located. And it also applies to the habitat in which they reside. Oftentimes they have designations of critical habitat, and even if the critter or plant is not found on that land, it's still protected because it's important to the species. This is another area where you have to do tremendous consultation with the U.S. Fish and Wildlife Service, which is an agency within the Department of the Interior. For most of these large-scale projects, it requires what's called a biological opinion. This process can take a minimum of, 240 days. Regulations say it shouldn't take longer than that, but it often can span multiple years. Depending on the sensitivity of the species, the project proponent is often required to develop a habitat conservation plan or a voluntary conservation plan, to avoid or minimize potential impacts to that wildlife species and or to that critical habitat for that species. So separate and apart from all this at the federal level, states have their own listed species. They might not be listed at the federal level, but they have their own sensitive species in that particular state or region, and you have to comply with the same types of processes at that level. Now, a picture is worth 1,000 words. So this is just one example of the geographic scope for some of these range-wide species. And this is a map of our friend, the northern long-eared bat, and where the habitat and range is for this species. It is listed under the Endangered Species Act. As you can see, this covers most of the eastern United States and the Midwest. So when you're citing your project, you have to go through that consultation process, with the U.S. Fish and Wildlife Service. You'll have to obtain a permit, for your conservation plan for your project. And this can take years. I've had some of these take 2 and 3 years. Some of them have taken longer. On the other hand, if you work proactively and do your diligence on the front end, you can get this process done much faster in a matter of months as opposed to a matter of years. My second example is in the western United States. And these green shaded areas show sagebrush habitat. And there's over 300 species that rely upon sagebrush habitat. This area is often called the Sagebrush Sea. It encompasses 11 different states, over 168 million acres. And one of the species that is most prevalent in the western United States and in these areas is the greater sage-grouse. It's a land-dwelling bird, and it's not listed, but for various federal land use plans, there are numerous restrictions related to protecting this species and its habitat. And just giving one example, in Wyoming, for example, if you're going to have a project traverse through greater sage-grouse habitat, there is a limit of a 5% surface disturbance. So you have a cap on the amount of surface disturbance in that geographic area. And the challenge is that's not a 5% cap related to your particular project. That accounts for the legacy landscape. It accounts for other development projects in the area. So 5% isn't a lot, and that creates a lot of competition between projects. That also creates competition between different industries. You might have a mine nearby, or you might have some oil and gas fields nearby. You might have, some other a highway or some other type of infrastructure. All that comes into account. So when you think about those other stakeholders, you can also think about it as potential plaintiffs or potential people that might challenge the project, or people that you need to negotiate and collaborate with in order to reach an agreement that'll work for everybody. Another consideration is federal land ownership. And this map provides a good representation of that. The blue areas are U.S. National Forest Service lands, managed by the U.S. Forest Service, which is part of the Department of Agriculture. The red areas are Bureau of Land Management managed lands. BLM is the nickname. BLM is an agency within the U.S. Department of the Interior. And as you can see, obviously, as you traverse farther west, you have more federal land management agencies to work through. Bureau of Indian Affairs is another big one. Many Native American tribes, promote renewable energy, and you still have to work through federal permitting. In some cases, you're working with the tribe directly as a quasi-sovereign entity, and then you're also working with the Bureau of Indian Affairs, which is also in the U.S. Department of the Interior. And we've just went through what those, land management agencies are. And just a comment here, when we think back to the strategy in the four-dimensional chess, in addition to needing a strong legal team and a strong environmental contractor, you really need to have a strong government affairs team. And it's really important to think about these agencies in 3 or 4 levels themselves, making sure that you're having consistent messaging with the senior managers in the Washington, D.C. at the department level, the regional office level or the state office level for a particular bureau or agency, and then the field office level for that particular agency. Oftentimes you will see disconnects. The local office and the state office might not be on the same page or have their same understanding of what the issues are that need to be navigated. And then there's even usually more of a disconnect when you get to working with the state and local regional offices for these agencies, and then working with their managers in the U.S. Department of the Interior, for example, in Washington, D.C. And a really cohesive government affairs strategy is being able to message up and down that chain so that everyone understands or has the same picture of what the project is, what those potential issues are. If there's a particular resource area of concern or a particular legal issue of concern, again, having that messaging at all levels, you want to provide that roadmap in terms of here are the issues, here's our proactive win-win solution for them, here's how this can be achieved, here's why this is in the best interest for that resource or particular conflict issue, and here's how you can achieve it within your legal authorities. In terms of the federal land side of the equation, the statute here that is the driver is the Federal Land Policy and Management Act. Our nickname is called FLPMA, for this one. And this really focuses on the creation of federal land use plans. And I have a slide here that's going to demonstrate this pretty well. But just as a general matter, each particular discrete geographic area in a state has its own federal land use plan. And this includes the eastern United States, even though there aren't as many federal lands. But in the western United States, for example, in Wyoming, you could have 9 different federal land use plans just for that one state. And the important thing here is that these land use plans govern, what you can and cannot do from a construction standpoint and from a development standpoint. And this is the graphic that I like to use most often to put it all into context. Think about a federal land use plan, also called a resource management plan. It's like a zoning ordinance. A zoning ordinance can tell you what areas are open for commercial development, what areas are open in a particular area for industrial, what areas are residential. A federal land use plan is the same way. Where can you, site an electric transmission project? In these particular areas, what types of construction restrictions or mitigation measures need to apply? And so when you're building upon your project from an environmental documentation standpoint, everything that you do up the chain of command on your permits needs to conform to that federal land use plan. So obviously, if you have an electric transmission line and you're going through 3 or 4 states and you've got 8 or 9 different federal land use plans, they're not all the same and they're not always consistent. You need to make sure that you have an understanding for each one of those plans what those requirements are and have a good understanding of how they might intersect with other state and local issues so you can try to navigate through them more efficiently. In terms of federal rights-of-way, these are primarily managed by the Bureau of Land Management. Not going to go into too much detail here. I have another example that shows where just because you have a federal right-of-way permit to traverse federal surface doesn't mean that you've solved all your problems, and there are other things that you need to consider. The good news is that in terms of the rentals that you pay with a BLM right-of-way, they're pretty fair in terms of fair market value, and that's really not the issue. The bigger issue that we're seeing these days is that a federal right-of-way requires bonding, and you have to post a bond, to make sure you're guaranteeing for future reclamation areas to restore disturbance from construction. And we're seeing the price of that bonding go up tremendously as BLM has had an issue with companies not following through with their permit requirements after the project is completed. Checkerboard land ownership. Again, this is more of a Western issue, but we also see this a little bit in the East Coast and the Midwest as well. Checkerboard lands are actually a creature of grants from the federal government to railroads. This dates back to the 1840s and the 1850s. And these railroad grants create this with checkerboard land ownership. For this particular diagram, you can see yellow squares and white squares and blue squares. And the orange or yellow squares are federally owned surface managed by the Bureau of Land Management. The white areas are privately owned surface, and the blue areas are lands that are owned and managed by the state. This particular example is in central western Wyoming. So if you have a federal right-of-way, that doesn't necessarily guarantee you access, across those private lands. You still have to enter into a surface use agreement with those private landowners. And when you have this type of checkerboard ownership, that's a lot of things that you need to account for. We were brought in one particular case where a company had obtained a federal right-of-way, but they hadn't done anything else, and they thought they were free to go through and traverse the entire length of the right-of-way, including state lands and private lands. They quickly learned that they actually had to comply with all those different components. The takeaway here, very time-consuming, can be very expensive, and can create litigation risk. And again, a lot of proactive due diligence ahead of time when you're citing and looking at these issues can go a long way to reduce those timeframes. Another issue is federal mineral ownership. Again, this is primarily a Western issue, but you can see the blue shaded areas. There are other federal minerals reserved across the United States. And in some instances, the federal government, reserved ownership of the underlying minerals, even if they conveyed the surface, to private landowners or to the states. And, federal minerals is broadly defined. You have hard rock minerals, you have coal, you have natural gas, you have oil, you have potash. There's a whole host of different things that need to be accounted for. Why is this important? Because it gets even more complicated. Oftentimes, and this occurs in private lands as well. We see this a lot in Texas. We see this a lot in western states. We see this in Oklahoma. But the surface might be owned by one landowner, and then the minerals underlying it, whether they're federal, owned by the federal government, or privately owned. Not only that, but in some of these areas, in Texas, for example, you could have 5 or 6 different mineral owners for different geological zones and a separate surface owner. What does this mean? Well, when you're traversing an area for an electric transmission project, you need to make sure that you have surface use agreements with the surface owner, but you also need to make sure you have agreements with the underlying mineral owners as well. Why? For 150 years, the law is generally consistent in the United States that the mineral owner has the dominant estate, meaning that the surface owner cannot restrict access of the mineral owner. And we've been involved in situations where, negotiating on behalf of transmission companies, working to make sure that all these different mineral owners are accounted for, making sure that there's fair accommodation. Some of those surface issues might drive what the parameters of those agreements are. So as you can see, I'm kind of building in complexity here. You might be considering checkerboard land ownership. You might be considered a split estate situation with different surface owners and different mineral owners. And you're looking at this at the federal level, you're looking at this at the state level, and you're looking at this at the private level. So it's very, very complex. And some of these issues, as a result, take a long time to navigate and get through. Just real quickly, a few additional slides. When we talk about the Endangered Species Act, we talk about what those conditions of approval might look like. Most often they come up in forms of seasonal restrictions as to when you can perform construction and when you cannot perform construction. This one example is a real life example, again in the western United States, and a whole host of different wildlife issues. Big game wintering areas, pretty much restrict no construction during the winter time. You have various fawning and calving and mating seasonal restrictions where primarily in the spring you can't construct during the spring because you don't want to disrupt the habitat. And this is something, or the species, this is something that's driven both at the state level and at the federal level. And then of course you have some wintering issues that extend into the fall. For this particular real life example, the construction window was really limited to September and October. That's not a lot of time. One of the things that you need to think about in working through these types of issues, whether at the state or the federal level, making sure that you structure your permits so that you have flexibility to the extent you can obtain it, so you can get more variances or more opportunity to expand that window. If you can expand that window, you very much need to think about what that construction window looks like, and then you've got to build your schedule around it so you don't end up having delays. There have been instances where companies did not get through their construction and they were required to stop construction until the end of those seasonal restrictions. That can extend up to 7 and 8 months in some instances. Obviously, a lot of delays, a lot of stranded capital. Unfortunately, these types of restrictions also are subject to litigation. You have a variety of environmental organizations that really focus on wildlife issues, and this is a big focal point that they have for them. They know what those seasonal restrictions are, and when they time their litigation, usually it's not coincidental in terms of the filing of that litigation, and they soon to have a closure for that wildlife restriction. In terms of Native American tribes, again, across the entire United States, but it's really important to think about these in terms of, you're negotiating with a quasi-sovereign entity in the form of this tribe, and, they have their own permitting authorities. In addition, you're coordinating with the Bureau of Indian Affairs on the federal agency side, and this is another situation where it's a very sensitive, balance in terms of working through those issues. And the more you can do to be proactive and relationship build on the front end, the better off you are in the long end. In terms of litigation risk management, we've seen almost every single electric transmission project receive some form of legal challenge, primarily by environmental organizations. And, when I started my career on the natural gas pipeline side, and I span forward 3 decades, it's the same environmental organizations, it's the same legal issues, it's the same, permitting issues. And, a lot of these federal permits and a lot of this environmental documentation, it really is Exhibit A to their lawsuit. So when you're working with your environmental contractor and with your legal team, you really need to make sure that you're doing a lot of due diligence to identify where these potential trigger points are. You might not be able to make the litigation go away, but you can make sure that you've got a robust administrative record to defend that project and make it more defensible in court. I think that's about all I can cover, in the time that we have. I know I went fast. I know I went through a lot of different areas, at the state and federal level. But I think it's just important to think about when you're looking at that permitting. You definitely want to think about it in terms of, what that 4-dimensional chess game looks like. And, one of the things that is really important is when you're developing your Gantt charts, you got to make sure you're accounting for these state and local permitting timeframes. You have to make sure you're accounting for, community outreach. Make sure you're accounting for, outreach to the federal and state agencies. The first time you meet a federal regulator, you don't want it to be when there's a problem. You want to make sure that you've developed that relationship in advance so that if a problem comes up, you guys can work collaboratively to solve that problem. We've seen many instances, regardless of the type of project, where it turns into a very adversarial relationship, between the state regulator or the federal regulator or at the local level, and that usually does not end well. It's a situation where, you guys all want to be working on the same page because you're going to have other stakeholders that you're going to have to work through and contend with in the formal litigation or whatever that might look like. So that's it. I'm going to turn it back over to Charlie, for questions. I look forward to trying to answer them. And if I can't, I can definitely find the answers really quick and follow up.
Okay, thank you, Brett. After listening to the hoops you have to jump through to get a project permitted, I'm left wondering how we get any projects permitted at all. Okay, we got a fair number of questions here, and I'm going to start with some of the popular ones at the top of the Slido list. First one is, what new federal or state legislation do you think would be helpful for transmission siting?
I love that question. I've been thinking about this a lot, and I think we have a real opportunity in the United States right now to pass some federal legislation to help electric transmission projects. And the analogy would actually be Section 4 of the Natural Gas Act. So in 1978, if you think about the 1970s and the oil embargo, and there was really constraints on natural gas and oil and energy resources, Congress passed Section 4 of the Natural Gas Act. That gave permitting authority to the Federal Energy Regulatory Commission, FERC, being the lead federal agency. And it also provided, once you had a certificate of public convenience and necessity, that you had eminent domain authority that you could then bring forward, at the state level. And there have literally been thousands of miles of natural gas pipelines permitted in this process. And FERC is very efficient compared to other federal agencies. So taking that analog, I think this is a great opportunity to have something equivalent for interstate electric transmission projects. I think that FERC is great to work with. They're very, very efficient. They do things very well. When you're dealing with one federal agency as the lead, it makes it a lot easier. When you're trying to deal with 4 or 5 different federal agencies within the Department of the Interior, and you're trying to deal with Forest Service and other ones, it just compounds the delays. So that would be my advice at the federal level. At the state level, we're seeing, some states like Montana have actual siting legislation, designed for electric transmission projects. A lot of states don't. But I think if you address this at the federal level and follow that type of model, I think it would be really helpful for everybody.
Okay, thank you. And the next question, given the importance of transmission to decarbonization, would you expect to face the same environmental opposition to national interest transmission corridors, I guess, in the future as there has been in the past?
Unfortunately, yes. I think that in working with these organizations or litigating against these organizations, I don't see a decrease in scrutiny from these environmental organizations. They're primarily driven by resource issues, and while there's an overall goal for reducing the carbon footprint and relying more on renewable energy resources, I think we're already seeing an increased focus of these groups on renewable projects. There's been a lot more scrutiny with wind projects and mitigation measures that need to be imposed or incorporated into those projects. And I think that we're going to continue to see this trend. So while there might be that overall goal, for a lot of these organizations, they're very resource driven from a wildlife standpoint or from an environmental impact standpoint. The challenges that we saw to the transition corridors in 2011, 2012, I think we're going to continue to see that trend. I don't think it's going to supersede, the overall goal of decarbonization isn't going to supersede the individual goals of many of these types of organizations.
Okay. But there's a couple of questions here on a related note having to do with use of other rights-of-way or other corridors. One on highway or railroad right-of-ways. Does that any opportunity to use those right-of-ways for transmission? And there's a couple more further down. Any plans to take advantage of other critical infrastructures, e.g. railways, to simplify transmission expansion permitting? And then one on, is it possible to draft permitting off of right-of-ways that already have been permitted and simply add value to the existing legal agreement? So different aspects of the same sort of question.
These are great questions, and I will try to tackle them, collectively. In terms of the last question, are there opportunities to tier off of existing, project approvals? At the federal level, the answer is definitely yes. We talk about environmental documentation under the National Environmental Policy Act. It does contain specific regulations where you can tier to and rely upon those prior studies. So there are opportunities to create efficiencies at that level. In terms of, are there opportunities on the highway side or the railroad right-of-way side? I think it's a mixed bag. The U.S. Department of Transportation, there are very specific restrictions in terms of what can and cannot occur, within those existing rights-of-way. It does trigger additional environmental review and permitting, requirements. Is it possible to be outside of that highway right-of-way and parallel it? That's possible. You're still going to have to go through all those steps, but to the extent that that environmental analysis has been achieved, a lot of times you'll be able to, try to create some efficiencies there. Railroad rights-of-way, same type of situation. You do have that opportunity to create those efficiencies, but it really depends on what that prior documentation looks like. So you really need to conduct due diligence on what was performed and actually looking at, were there legal challenges to that particular highway, railroad, or other infrastructure project? I think there are opportunities also with, rights-of-way for, natural gas and oil pipelines. And, again, there's safety concerns in terms of siting, you obviously can't be in that specific corridor, but if you're looking at adjacent lands, again, you can create some of those permitting efficiencies at the federal and state level. And one of the comments that I see in the middle is, can you comment on the relative ease or difficulty of permitting electric transmission compared to, natural gas or oil pipelines? As it relates to natural gas pipelines, I think those are the easiest because, again, with Section 4 of the Natural Gas Act, FERC has that primary permitting authority. For an oil pipeline, it's much more fragmented, and you're dealing much more on a piecemeal and ad hoc basis. You don't have that centralized authority, so you're dealing with it, in a much more localized area in terms of getting your federal permits. And that results in, requiring, coordination with a lot of different federal agencies. U.S. Army Corps of Engineers, for example, is in charge of permitting, certain components of the Clean Water Act. So if you have a water crossing or some wetlands or something like that, you're working on those types of permits. If you're involving the Endangered Species Act, you're involving the U.S. Fish and Wildlife Service from the Department of the Interior. If you have federal surface managed by BLM, obviously you're working with that agency. In some cases, you're working with all of the above. So as it relates to oil pipelines, but also as it relates to new electric transmission lines, I think there's the same level of inefficiency. Just because you have so many different federal agencies involved, you don't have a centralized process, and I think we see very similar delays for those projects. And then we also see very similar legal challenges from the same types of environmental plaintiff organizations between those types of transmission projects and those types of pipeline projects as well.
Okay, Brett, there's an interesting one down here that relates to an activity that ESIG has been working on for the last couple of months. In your opinion, can NEPA be compatible with a 10 to 20 year build out of a supergrid? I think I may have mentioned this in one of our earlier conversations with you. The supergrid is a series of high voltage AC and DC transmission lines that would actually span the continent. So compatible with a 10 to 20 year build out of a supergrid to support a transition to clean energy and tie regional grids together. Not just tie the regional grids together, but also bring in remote renewable energy from wind and solar regions that are far away to load centers. Sort of a big national effort, I guess, the way you could look at it.
Yeah, and I think there are opportunities. I think that it does have to occur via federal legislation, kind of a top-down approach, so you have a more centralized approach, to doing that. I think there is, obviously, I think Americans understand the need, for this to occur from a policy standpoint, but also they understand it from just having an electric reliability standpoint. And obviously in the West Coast, they've experienced more of those issues. So I think there is an opportunity to look at these things together in terms of the grid and in terms of coordinating these areas, but I think it is going to require federal legislation to try to make that happen. I mean, when we look at the evolution of the electricity system, I mean, very localized, very regionalized, I would say tribal in some instances in terms of how it's evolved. And how it's evolved in terms of state permitting and state legislation. I mean, there is just a tremendous amount of diversity. So to achieve that overall type of goal, you need to have more uniformity. And I think we have a good opportunity, to do that. I don't view a super grid or, interstate electric transmission as being a partisan issue. I think that it's something that everyone can see the value in, and I think that we've got that opportunity to work with, this Congress, hopefully, to try to develop some of that.
Okay. Here's one. You can punt on it if you want, Brad. It's not a real technical one, but what do you do to build social acceptance of new transmission corridors, and how does it benefit permitting? A social science one, I guess.
No,
Any thoughts on that?
Absolutely. That is a great question. And, whether I'm working on a water pipeline, an oil pipeline, a natural gas pipeline, electric transmission project, a helium project, a potash mining project, I mean, all have the same issues. And that is, how can you develop this community outreach so that you can build, some form of consensus. And if you're not building support for the project, at least you're not building opposition to the project. And it's amazing how far you can go with these types of projects where you have an open house. where you work through the local farm bureaus and present to the local farm bureaus, where you might work through a local ranching organization. If there's a lot of oil and gas resources in the area, make outreach to the oil and gas trade associations. I think that the more that you can do that and identify who those stakeholders are, identify what those local interests are, and then be proactive. Here's the project that we're planning. Here are the benefits that are going to provide. Here's how we are going to be corporately, socially responsible as a project proponent. Here's how we're going to collaborate and work with you and be responsive to your concerns. That sounds like a lot of work, but that little bit of investment on the front end can literally save you years on the back end. And from a permitting standpoint at the local and state level, and then also at the federal level, the more opposition you see to a project, the more sensitive it gets at the higher and higher levels, whether that's the governor of a particular state or whether that's political appointees in Washington, D.C. for whatever federal agency, or even, with the White House. So I think that it's a great question, and I think that is something that needs to be focused on. Now, you're not going to get the same messaging, in terms of trying to think about it from a policy standpoint. Not every local community is going to really fully appreciate or support or necessarily believe in the broader goal of whether it's decarbonization or electric reliability. They're going to have much more localized interests. And I think it's just a matter of adapting your messaging so you're focusing on the things that they need to hear or need to understand. I'm not saying you have to promise them everything in the sun and the moon in the world, but by having that candid discussion and really being collaborative and listening to their concerns, 9 times out of 10, you're going to get where you need to go.
So it sounds like a little bit of human relations can go a long way.
I do say it's like the equivalent of a political campaign if you're running for an office, but at the same time, we've seen that work with great success. Now, candidly, there have been other projects where that has not occurred, and the exact opposite has occurred, and we've seen delays for those other projects.
Okay. All right. Question: what's the biggest risk of conflicting requirements between state and federal regulations? Are they often in sync or often at cross purposes?
I think it depends on the particular resource issue, to be honest with you. But overall, let's just take a wildlife, for example. Most often you will have very similar requirements. Sometimes the state has more stringent requirements. Sometimes the federal government has more stringent requirements. But at the end of the day, it's not something where it's going to result in additional delays, because what you're going to address you take the lowest common denominator, or I guess I should say you take the highest common denominator in terms of complexity, and if you can address that, whether it's a state issue or a federal issue, it'll help dovetail those issues, at the state, local, and federal level. In terms of cross purposes, where those often conflicts occur is more along the lines of at the county level. There was actually just an article a few weeks ago. There was a county in Wyoming that rejected a particular electric transmission project because they thought it was going to conflict with mining operations or take away jobs or something like that. And that's a situation where you're looking at land use planning, you're looking at jobs, you're looking at what the drivers are for that local community. You're going to find it more often on the political side than you are going to really find it on the permitting side. Clean Water Act is another example where you do have that delegation of state authority where they have primary authority, and you just need to make sure that it's being done in the proper manner so you've got that compliance across the board.
Okay, I think we're getting close to the top of the hour, but I want to ask one last question that didn't quite make it up to the top, and it's from your perspective, what could be done to simplify and shorten permitting of transmission lines?
Well, first and foremost, what we already talked about, working together to get that federal legislation so you have that primary siting authority with FERC and working through. But from a practical standpoint, what I see when I'm brought in on a project on the front end of the process, working and doing that due diligence, working with the environmental contractors, identifying issues with your land company and your landmen and identifying those access issues, working with your government affairs specialists to identify particular political pressure points that you might encounter at the state, local, or level. And when you put together that plan on the front end of the process and you work out what that timeline is going to look like, and you can identify where those delayed points are, you tackle those first. That proactive effort will save you months, if not years, on permitting. Now, there have been other projects where I've been brought in on the back end where there was a general concept for a large-scale linear project to move forward, but I was brought in to try to fix it. That's always hard. No matter what the issue is, if you haven't done that front-end work, it takes twice as long. And some people are like, well, I didn't want to pay an attorney to get involved on the front end. I wanted to save money. Well, whoever you hire, it's going to cost 2 or 3 times more to fix a problem than it is to prevent a problem. So hopefully that makes sense, but it's one of my favorite topics of conversation in these types of issues.
It sounds like some good experience to draw on there. Okay, as I mentioned earlier, we need to wrap it up now, and an email will go out once the video file has been posted, and we'll answer the questions we didn't get to and get the answers posted as quickly as possible. We appreciate your engagement and look forward to seeing you at our 3rd webinar in the transmission series, which will be held on February 24th at 2 p.m. Eastern. Steve Gaw of Advanced Power Alliance will be speaking on transmission cost allocation. Our next webinar in the GPST series, remember the GPST, will be held tomorrow at 4 p.m. Eastern. Christian Schaefer of AEMO will be speaking on their work on developing an engineering framework to support Australia's energy transition. We hope you'll be able to join us once again for one or both of those events. Further information on all of our webinars and meetings can be found on our website at esig.energy under events, and our newsletters and emails, and you're all invited to attend. Brett, I want to thank you again for this very timely and informative walk through the legal and regulatory maze of transmission permitting, and thank all of you for your interest. We look forward to seeing you again soon. In the meantime, everyone, take care, stay safe, and thanks again for your participation. Farewell for now.